Okay, welcome to the video lecture series. This lecture is going to be on contracts law, and we're going to initially start with the first few elements of contracts, which is offer, acceptance, and consideration. We know that from your reading, you know that there's I call those three the primary elements of a contract, so offer, acceptance, and consideration. The book refers to offer and acceptance as the agreement, which is fine as well. We'll kind of talk about what that means when we define those things. But we're looking at agreement and consideration, agreement containing offer and acceptance. And then ultimately, after those three primary elements, you need to have capacity, legality, and then finally, we're going to look at whether that contract has to be in writing to be valid. So I say six elements to the contract, three primary elements, and then three elements that additional elements of capacity, legality, and writing. So offer, acceptance, consideration, capacity, legality, and writing. So the first thing we're going to do is just define what a contract is. And as we start to study contracts, sometimes it's just a good thing to start just at the basics and define some of the language of contracts itself. So as you can see in the outline, and again, I'm using the outlines that I've posted on Canvas, so you can look through these outlines in Canvas as well and refresh your memory, and I'll add to these outlines in this lecture, but I'm using them to form the basis of the lecture. So as you can see in the outline, contract is defined as an agreement that can be enforced in court. It is formed by two or more parties who agree to perform or refrain from performing some act now or in the future. So simply, what is a contract? It's a legally binding agreement between two parties. So the important part about a contract is that it's binding. It's enforceable in a court. So the reason why a contract is so important, at least to understand, is that it does give the potential for a remedy if one party breaches that contract, and that's really why we want to look at it and understand what it means. So, as opposed to a non-legally binding kind of agreement, and we'll understand what that means is really not an agreement at all, right? If someone says something that doesn't rise to the level of an agreement, offer and acceptance, then it's not contractual, and that would mean that I couldn't go to court and enforce that agreement because it doesn't rise to the level of a contract. When we're looking at agreements, we're trying to determine whether they rise to the level of a contract. If they rise to the level of a contract, then that's a legally enforceable agreement, meaning I can go to court and say, hey, this person breached something that they said they were going to do or perform in the future. They didn't perform as they said they were going to, and so I can seek damages for this non-performance. We call that breach. So I would seek to sue the other party for breach of contract. So again, defining a contract as a promise or set of promises for the breach of which the law provides a remedy or the performance of which the law imposes a duty to act. Right? These are just another way of looking at it, as the definition in the outline suggests. I'm just giving you some more definitions to kind of understand what the definition of a contract is. So now that we kind of understand by definition what a contract is, I'll kind of pose this question: Why would we want to study the area of contracts, and why I think it's one of the most important areas that we study in this business law course is contracts. So why would we want to study contracts? Take a minute to think about that, and then we're going to discuss why it's important. So I would say it's really important that we study contracts because we need to understand this foundational understanding of how agreements are formed. And I kind of already mentioned this before, is that we will see when we study this that sometimes discussions between parties and, quote, agreements aren't legally enforceable agreements because foundationally they don't adhere to the requirements of the law as it relates to forming a contract. So it's important as we go through our business careers and just through life and enter into contracts for purchases of cars, or a contract for the transaction of real estate, buying or selling real estate, or entering into a contract to with your gym membership. There's tons of contracts that we enter into throughout our lives, and we want to understand the rights and responsibilities that are required when we enter into a contract. We want to understand how one is created foundationally. What are the legal requirements for a binding agreement? And then ultimately what we would resolve a dispute and what that would look like, how we resolve this breach of contract if we have a contract and one party doesn't perform. And then we also just want to understand what it means to enter into a contract so that we can avoid or minimize potential legal conflicts. Ultimately, that's why we're in the business law class and studying this section on contracts. So contracts are governed by the objective theory of contracts. And what this means is, I like to describe it as when we're looking at whether a contract has been formed, whether the parties intended to enter into a contract, we're going to look at objective facts interpreted by a reasonably prudent person. So we're not going to look at subjective or secret intent, but more of the outward expressions of the parties as they were interacting to form this potential legal contract. There's a case that I have talked about, or is in your book. It's called Lucy v. Zimmer, and this is kind of a seminal case on the objective theory of contracts. And in that contract, or in that hypothetical, there was a lot of discussion about the parties' actual intent to enter into the contract. And in the Lucy v. Zimmer case, we had them sitting down and drinking and having dinner and talking about this idea of selling real estate. One party was selling, one party was buying. And in the facts of this case, they were consuming alcohol. There's also facts in this case that suggest that the seller went to his wife, who was not in eating dinner but was in another room, and told her that he was just joking, that the buyer wasn't really going to buy the property because he didn't have the money. Then he would come back to the table and talk to this gentleman about selling it, and in the seller's mind, he was joking. He wasn't really intending to transfer the property to the buyer. And what the court looked at was this idea of what was the objective outward expressions of the parties, not secretive or not subjective intentions, which we might define. And in this hypothetical, there was a written document that said, "I do hereby agree to sell." This was a farm they were selling. It said something like, "I do hereby agree to sell to the individual the dirt farm," period, right? And so they had this document that purported to transfer the interest in real property to another person. And so the court really looked at this and said, well, if this document really says that and really says you want to transfer the property, then your secret or subjective intentions, because the seller argued at trial that he never intended to sell the property, he was just joking. He went back and told his wife it was a joke. But he never expressed that to the buyer, that it was just a joke. And so the court looked at this and said, no, we can't rely on these subjective intentions. We're going to look at the objective facts that surrounded the agreement. And ultimately they decided that because of that objective theory of contracts, sometimes I'll talk about this in class as a 30,000-foot view, looking down, reasonable person looking down, seeing what the parties did, seeing how they interacted, what were the outward expressions of the parties. Was that enough to form the contract? And the court ruled in favor of the buyer and said that the secret subjective intentions weren't going to look at those. They were going to look at the outward expressions, the objective expressions that were made under those circumstances. And so you can look at that case, Lucy v. Zimmer, in the posted materials, or you can Google search it. I think I also put a video online for Lucy v. Zemmer, but that's what that case is talking about. And so we're gonna keep that in mind as we go through when we're talking about what an offer is, what acceptance looks like, whether we have an agreement, meeting of the minds of the parties. We're going to always look at it objectively, not subjectively, but objectively. So again, the elements that we're going to study. So in this particular video, we're going to talk about the agreement stage. So we're going to look at the first two elements. They talk about 4 elements required for a contract. I talked about 6. Understand that when they say agreement, they're including offer and acceptance. So you can either say there's 3 primary elements, offer, acceptance, consideration, which would be 3, or you could say 2 primary elements, agreement and consideration. I like to look at agreement as 2 elements. So offer and acceptance, and we're going to look at both of those elements today in this video. We're going to look then, I'll post another video where I'll do a brief discussion of the concept of consideration, and then I'll post another video talking about the last 2 or 3 elements, however you want to look at it. I look at another 3 elements because I like to include as a potential element the writing requirement under the statute of frauds, which we'll talk about contractual capacity, legality, and the writing requirement in another video. So like I said, for this video, we're going to stay with the 2 elements of offer and acceptance. Before I do that, I want to talk a little bit about this, the different types of contracts that can be formed. This is a discussion of classification, I guess, if you will, but it's also leads into analysis about revocation of offers and some implications as to offers being made and how they're accepted, when they can be revoked. And so we need to understand this material before we get into some of those other areas. So briefly, and we'll kind of come back to this when I talk more about the actual offers and what is an offer and what isn't an offer. But contracts can either be classified as bilateral or unilateral. So bilateral contracts are classified, well, when they're classified as either bilateral or unilateral, what they're really trying to do is classify the contract based on how and when it was formed. And so what they mean by bilateral is that the contract is formed when the promises are exchanged. So remember, we have to have an agreement, and we define contract as a set of promises, for which the law provides a remedy for breach, right? So 2 parties promise to do something or promise not to do something, but at any rate, we're having promises exchanged. When the promises are exchanged, we have what's created as bilateral contract, meaning that the contract is formed at the minute the promises are exchanged. Now, we can also have what are called unilateral contract formations, where the promise is made, but acceptance is done through an act. So acceptance can only be made by acting or performance. See the distinction? Bilateral is a promise for promise. Unilateral is a promise for performance, meaning the only way that the party can accept is to perform, as is outlined in the offer. So the distinction or classification is one between bilateral and unilateral. Bilateral being a contract that elicits a promise as acceptance, promise for promise, formed the minute the promises are exchanged, or unilateral, which is promise for performance or an act, and only when the party performs or acts is acceptance made. That's called unilateral contracts. So every contract, as I've kind of alluded to, is going to have at least 2 parties, right? We're going to have the offeror, who is the party making the offer, and the offeree is the party to whom the offer is made. So when we have this when I was talking about this bilateral versus unilateral contract, we're talking about the offeror, that's the one who makes the offer, and the offeree. So again, as a matter of form or classification, we talk about bilateral contracts being the offeror makes the offer to the offeree. The offer indicates that the offeror would like the offeree to accept by return promise, promising to perform. If that's the way the offer is written, then we have a bilateral agreement, promise for promise. If the offeror promises to do something and wants the offeree to perform, to accept that promise, then we have what is called the unilateral contract. So let's look at the agreement elements, which is offer and acceptance. We're going to come back. I talked about bilateral versus unilateral here, and we go into some of this revocation issues, but we're going to talk about them later. Let's first define what we mean by agreement, and then define offer and acceptance. So what is an offer? So an offer is a promise or commitment to perform or refrain from performing some specified act in the future. So when we talk about it, so again, we have to think about what is a valid offer. A statement that is not an offer is not a binding statement, right? Because remember, ultimately, we're trying to figure out when a contract becomes legally binding. And so if a statement is made but doesn't rise to the level of an offer, then that offer is incapable of being accepted because it doesn't rise to the level of an offer. So what does it mean to rise to the level of an offer? Well, there has to be serious objective intent by the offeror to enter into this contract. The terms of the offer must be reasonably certain or definite so that the parties in the court can ascertain the terms of the contract. So for shorthand, we call that definite and certain terms. So there must be serious objective intent by the offeror to enter into a contract. The terms must be definite and certain. And then thirdly, it must be communicated to the offeree. Remember, the offeree is the party who receives the offer from the offeror, right? We have the offeror, party who makes the offer, offeree, the one who receives it. So a promise or commitment to perform or refrain from performing some specified act in the future is an offer. Must be serious, objective intent to enter into a contract. The terms must be definite and certain, and it must be communicated to the offeree. So that's the first element, right? And as I said, remember, I'm going through them as three elements: offer, acceptance, and consideration. Whereas the book talks about agreement and then has offer and acceptance in that agreement. It makes sense because, let me step back a little bit, because if we think about contract law, is the agreement is what sometimes is referred to as mutual assent or a meeting of the minds. The parties must have a meeting of the minds or a mutual assent or mutual agreement to enter into this contract. That mutual assent is offer and acceptance. Where the offer is made, a promise is made, a promise is returned. Because remember, when we offer something, somebody is accepting that offer, which usually means that they're going to do something for the offeror. They're going to refrain from doing something for the offeror. But whatever the case may be, there is going to be an exchange, right? An exchange of promises made, right? A mutual assent, a meeting of the minds, that they are entering into this agreement to do something or refrain from doing something. That's what a contract is. So sometimes I like to define offer a little differently than the textbook and the outline here, but sometimes I'll give you my long-winded definition of an offer, which is a serious present manifestation of intent to contract. It's made in such a way to justify that the offeree believes that their assent is invited, their assent being their acceptance is invited, and if given, concludes and creates a contract, right? Serious present manifestation of intent to contract, so made to justify another person in believing that their assent or agreement to that offer is invited, is asked for, and if given, then that contract would be formed. We have mutual assent, a meeting of the minds. So we need to, once we define offer, right, which we just did, we kind of need to talk about things that aren't offers. Because an offer, so generally speaking, an offer is something that's made that is not serious. There's no present intent or objective intention to enter into a contract. It is not reasonably certain or definite in its terms, and it's not communicated to the offeree. If any of these three elements in an offer are lacking, then we don't have a formal offer. And again, what does that mean? Well, that means that then that offer is incapable of being accepted, thereby binding the parties to the contract. So when we talk about serious present objective intent, sometimes I'll talk about this offers that lack that, or offers that wouldn't be considered offers, right? It's hard sometimes when you're talking about, I should say, language that would not be considered to be an offer. Let's say you have a Ferrari out front, and you go out to start it and it doesn't start, and you're angry and you kick the tire and you say, I hate this Ferrari. If someone would give me $300 right now, I'd sell it. Dude walking his dog by your house, right? He hears you say it and he goes, I accept. He yells, I accept, whips out his wallet and gives you 300 crisp $100 bills. And you say, oh, no. And he says, no, you offered, I accepted. Well, in an analysis of that, you might go, wait, is that true? There was offer, acceptance. There's definitely consideration, Ferrari for cash. Do we have an agreement? No, right? Because maybe you would think that based on what we've read here, right? Oh my gosh, we have an agreement. But we don't. Why? Because the offeror would say, wait, there was no serious present manifestation intent to contract by me. I was yelling out loud, aggressively, and although it might have been definite and certain in its terms because I stated a price for my Ferrari, objectively, look, we go back to the objective theory of contracts. No one should think that a person would do that objectively, right? Objective theory of contract. Under this, the party's intentions to enter into contract is judged by outward objective facts, right? So reasonably under a reasonable prudent person standard. So objectively, that is not a serious present manifestation of intent to contract. So that's an example. Some other things that are not offers is language of negotiations, or sometimes referred to as preliminary negotiations. Would you be willing? I bet you wouldn't. I bet you wouldn't sell that for this. Would you be willing? Or would you consider this concept of selling that? These are preliminary negotiation language. They typically do not rise to the level of an offer. Expressions of opinion generally do not. There's a pretty famous case about a doctor who told a patient that if they had the surgery that they would heal in 2 to 3 days. Well, the patient had surgery and didn't heal for weeks or months. I forget the exact facts of the case. It's been a while since I've read it. But the idea was that then the patient sued the doctor for breach of contract, asserting that the statement of healing time was contractual, and if they failed to heal within that time frame, then the doctor had breached the contract that was made between the parties, and the court decided that that was more of an expression of an opinion, that the doctor was giving an opinion, not an assertion of serious, definite, and certain objective intent stated enough that it was contractual in nature. So preliminary negotiations are not offers. Expressions of opinions are not offers. And then the last one that is not an offer is what we call advertisements. So an advertisement is kind of a tricky one. So the general rule is we say advertisements are not offers. And when you think about the concept of why an advertisement wouldn't be an offer, is it makes sense. How would we do that, right? How would every ad that comes out, every circular that shows up in your mailbox, if we held it to the standard of contractual in nature, everybody that went to Target and asked for that, everybody would then demand that be fulfilled. Well, Target, if the entire county of Sacramento went in and said that, that particular Target, all Targets couldn't fulfill the demand. It just doesn't make sense. So when we kind of go through this objective analysis, this Lucy v. Zemmer, Objective Theory of Contracts, when we look at serious present manifestation, when we look at other such things, we realize we shouldn't allow these kind of vague advertisements to rise to the level of an offer capable of being accepted. The other kind of flag when we look at advertisements or catalogs or circulars is this second element, definite and certain in their terms, right? So this is tough, right? When you have an advertisement, because definite and certain in its terms, so that the parties can ascertain the terms of the contract. When we have these advertisements, a lot of times we don't have this, right? We don't have the exact price, the nature of the product defined particularly, the pricing, quantity, everything is off usually. Now, that's not to say, because there's a famous contracts case, again, as you can imagine, that shows the opposite, that an advertisement was enough to create a binding legal agreement between two parties. So what would be the difference between some vaguely worded, generalized advertisement and then an advertisement that might be looked at as an offer capable of being accepted, right? That first element in the agreement concept, right? The agreement element. So the court said if it is definite and certain in its terms, if it's identifiable, if it's communicated to a particular offeree or group of offerees, if there is objective, serious intent that can be ascertained from the document itself to sell that particular item. So what does that look like? Sometimes we see that where we'll see car dealers, perhaps, I'll use that as an example, or even Target could, for my example, Target might have some advertisements that border on offers. But definitely when we see car retailers, they call loss leader ads. A loss leader ad is when they send that ad out and that ad has a particular vehicle. Now what that does is they have a price, they have a VIN number or stock number, they have one at this price language, right? This communication of the terms, right? The first person that comes in here and is willing to pay this price for this specific vehicle that is listed here with the VIN number or the stock number or whatever number that can identify this vehicle particularly. It's that in and of itself kind of lends to the serious objective intent of that dealer to sell that automobile. So if I go in there and I say, hey, I want to buy this car, I saw your ad, and it has all those definite and certain terms, then that rises more likely to the level of an offer. And remember, we're talking about law here, and we're talking about legal arguments, so we could argue, right, both ways, right? Someone might argue it's not enough, the other person might argue that it is enough, but what I'm telling you here is that if we can find serious objective intent, definite and certain in its terms, and it is communicated either through advertisement or individually to one party, then we could argue that it is an offer. Generally speaking, advertisements are not offers, but the more they get into that realm of definite and certain in their terms and the nature of those terms, the more likely we might see an offer capable of being accepted. Now, just because they send out one and it says one at this price, first come, first serve, language like that, that doesn't mean 100 people can go in with the ad and force them to sell 100 cars at that price. No, because what they've done is created a loss leader, one automobile at that price. The first person that gets there gets it. Everyone else, the contract's been fulfilled. Once the person shows up and accepts that car as listed, then that particular offer is gone because it's been accepted. So they can't force them to sell many, many vehicles at that price. So as I've said, you can see that this definiteness of the offer they've added a little bit here in the outline, but I've already kind of talked about this, is kind of identification of the object or subject matter of the contract, the work, or specifically identifying the good, right, or land, the amount to be paid or consideration, delivery and payment. These are all things that really kind of lend themselves to analyzing this and saying that it is an offer. Okay, before I talk about termination of offers and some of this language or these concepts here about termination of an offer, let's first define acceptance. And remember, that an agreement contains the first two primary elements of a contract, offer and acceptance. We defined offer, right? A serious present manifestation of intent to contract. Then now on the end, we talked about what isn't an offer, and we talked about what is an offer. Now we say, well, okay, how do we fulfill the other side? Acceptance. So acceptance is this voluntary act by the offeree that shows assent or agreement to the terms of the offer. The acceptance must be unequivocal and must be communicated to the offeror. Only the person to whom the offer is made can accept the offer and bind the contract. So that is offer and acceptance. Acceptance seems like a little bit easier of an element to satisfy or to understand, doesn't it? We have offer because we're going to define, analyze objectively what it means, whether that was truly an offer. Acceptance is just this idea that the offeree says, I accept, I voluntarily assent to this agreement. Yes, I will do that in my return promise. I accept and I want to go through with the contract as it's written. So let's look at, we'll look at these additional acceptance issues or concepts, but I just wanted to define acceptance first so that we understand what that agreement is, right? We have offer and acceptance. And now I want to talk a little bit about termination of an offer, because sometimes the acceptance of the offer can cause issues, or the way in which the acceptance is made. So when you think about this idea and of this offer being open, right? So we have an offer is open. So an offer is a serious present manifestation of intent to contract, and it's made to another party, right? The offeror makes that serious present manifestation of intent to contract or promise to perform. I'll define it my way: serious present manifestation of intent to contract, an offer, or the way the book describes it, a promise or commitment to perform or refrain from performing some other act. They both work, right? A serious present manifestation of intent to contract, to promise to do something or not do something, that's conveyed to the offeree, right? So this offer goes out. So then the offer's open. So if an offer's open, it's capable of being accepted. So how long does it stay open? Years? Months? Right? So we have to then say, okay, when is an offer terminated? How can it be terminated? So the first thing that we can talk about is this idea of revocation. So revocation is an act by the offeror, so the party who made the offer, of revoking it, pulling it back, saying, nope, I'm done. I don't want my offer to you anymore. I'm revoking my offer. So we can revoke offers. Now, this is where I'm going to scroll back up here, because they kind of tried to talk about this too early, I feel, in the outline. But we're going to scroll back up now, and we're going to look at this concept of bilateral and unilateral as it relates to revocation of offers. Okay, because they started to talk about it here, but I think it was too early. Now that we've defined offer, and now we want to talk about revocation of those offers, this is where we need to understand revocation of bilateral versus unilateral offers. So revocation again is just taking back the offer, just pulling it back, saying, oh, you know what, I've changed my mind, I'm revoking my offer. It cuts it off, and it's no longer capable of being accepted. So revocation of offers in a bilateral setting, revocation of offers in a unilateral setting. So there you go. There's a distinction now. So when can the offeror, the one who makes the offer, revoke? How long can they revoke their offer in a bilateral setting? Remember, a bilateral setting is a promise for a promise. Simply, I can revoke my offer anytime prior to acceptance. The offer's been made. It's open. It has not yet been accepted. I can revoke. It's accepted. I can no longer revoke. Once the return promise is given, the acceptance is made, the offer is irrevocable. cannot be revoked. An attempt to revoke it is what we call breach, right? It's just saying I'm not going to do what I promised to do. So that's a bilateral contract, revocation in a bilateral setting. Remember, formation of bilateral contract is a promise for a promise. Now you say, I'm confused, Professor Granquist. Hey, this stuff's getting confusing now. Just take a pause, take a deep breath here, and think about what I'm saying. Remember that we classified contracts based on them being either bilateral or unilateral, the way in which the offer makes the offer and acceptance is to be made. Acceptance is either to be made by promising to perform, right? The offeror promises, and then the offeree promises. That's bilateral. In a unilateral setting, the offeror promises. The offeree then has to act or perform to accept. That's unilateral. Remember, it's not a promise to perform, but performance is required. So in a unilateral setting, when can the offeror revoke? Unilateral, once the offeree has started to perform or attempt to perform, well, we'll say performance, starts to perform, once the promisee has begun for performance, but before the act has been completed, you still can't revoke. Because you can't revoke when you've said, hey, you have to perform and if it takes a while to perform, I can't revoke while they're performing. So let me try to give you an example. I use this example a lot, and hopefully it makes sense to you. Let's say that I want to buy a boat, and I want to buy or let's say a yacht, a big boat, and I want to have it for my birthday, or I want to have a birthday party on the yacht or something, right? And so I say to the seller of the yacht. So the seller is listing this yacht for sale, and I reach out to them and I say, okay, I offer to purchase your boat. I promise to purchase your boat for whatever sum of money. Let's just say $100,000. I don't know what they cost. I don't have any boats, but let's just say it's $100,000. And the seller says, okay, and you say as the buyer, we're switching kind of offeror offeree, because I'm going to say with my offer as the purchaser, I'm going to say with my offer, okay, I promise to purchase your boat if you promise to sell your boat, right? I promise to pay $50,000 for your boat if you promise to sell your boat and deliver it to me. Is that a bilateral or unilateral? It's bilateral. I promise to purchase the boat, you promise to sell it to me and deliver the boat to me. Great. Remember, all contracts are going to have exchange of promises and performance tied to them. Just because there's performance doesn't make it unilateral, right? There's always going to be these promised performances. So let me change it to unilateral. I promise to purchase your boat for $50,000 if you sail it from San Diego, let's say it's in San Diego, to my slip in San Francisco Bay by Friday. Let's say it's Monday. And I say, but you must deliver it by Friday because I'm going to have my party on Saturday. And so now I've changed it, right? I promise to purchase the boat if you deliver the boat to my slip by Friday. Otherwise, I am not purchasing it. That's unilateral. The acceptance is done by performance, not promising to perform. Could I still create a bilateral? Do you understand the difference? Can you create a bilateral and a unilateral just as I did in your own mind? Take a minute. Yeah, right? So here's what you do. You say, and let me throw a little curveball. Let's say that I say, okay, I promise to purchase your boat for $50,000. If you promise to sell it to me, delivery to be Friday. Is that bilateral or unilateral? I promise to purchase your boat for $50,000. If you promise to sell it to me, delivery to be Friday. It's bilateral, isn't it? We exchanged promises. Delivery by Friday is a term of the contract. Now you would say, oh, Professor Granquist, I don't get it. I thought the performance was unilateral. Don't do that. Remember, the nature in which I made the offer is wanting the exchange of promises. The only way I can make it unilateral is the acceptance is via performance, not saying if you promise to sell it to me. Because remember, in the sale of a good, I can promise to sell it. There ultimately always has to be delivery. At some point, they're going to deliver it. So if I promise to purchase, you promise to sell it, and we define delivery as Friday, it's been accepted. It's formed the minute the promises are exchanged. Delivery by Friday is a term of the contract. If they fail to deliver it by Friday, does that mean I don't have to pay for the boat? No. It means I still have to pay for the boat, but I could get damages for their breach because they didn't deliver on the time that was specified in the contract. So I could sue them for damages, but I can't say, well, I'm not buying the boat anymore, because that's not a remedy that the court would adhere to. There could be a remedy for, I don't know, the timing discrepancy between when they said they were going to deliver it and when they actually did it, whatever damages you could show. But let me flip that now and say it's a unilateral contract. I promise to purchase a boat for $50,000 if you sail the boat and have it delivered to my slip by Friday. That I did not ask in my offer for them to promise to sell it to me and then deliver it. I said you must get it to me by Friday for acceptance to occur. That's the difference between bilateral and unilateral contracts. Now, revocation becomes very important. If the promises were made, promise for promise, I can no longer revoke. In a unilateral contract, I promise to purchase for $50,000 if you sail it and have it in my slip by Friday. I can revoke any time prior to the start of performance. Once they start sailing the boat to me, I couldn't revoke, because that's what we were talking about this issue with the inability to revoke unilateral contracts once performance has begun but has not yet been completed. Okay, so I'm going to pause and catch my breath a little bit, and then we're going to go back down and talk a little bit more about termination of offers, and pushing the 40-minute mark, but I'm going to try to speed it up here. All right, so we've caught our breath and we understand. So remember, always hit me up to schedule a Zoom session if you want to go over this in person. I know teaching this in person, on ground, on campus, students really kind of struggle with this concept of bilateral versus unilateral. So if you want to have a live Zoom session, let me know, email me, and we'll get together. So again, so where are we? So we've defined offer, we've defined acceptance. They form the first two elements of a valid contract, offer and acceptance. The third primary element is consideration. We're going to talk about that on another video, but now we have defined offer, we've defined acceptance, we've talked about bilateral versus unilateral, we've talked about revocation of an offer, where the offeror revokes or pulls back an offer. When can they do it? Bilateral versus unilateral. There's a distinction in that, right? Bilateral, anytime prior to the return promise. Unilateral, anytime prior to the start of performance, because the nature of unilateral requires performance for acceptance, not a promise to perform as acceptance, as in a bilateral. So now what else terminates an offer? So we know revocation can terminate an offer. Well, if the offeree rejects, they can just flat out reject. No, I will not. So I offer to purchase your boat for $50,000 if you promise to sell it. No, I do not want to sell my boat for $50,000. I reject. That's rejection. Terminates the offer. That means the offer is no longer live, because remember, offers are alive and capable of being accepted until they're terminated. Termination by revocation, termination by rejection. This is an act by the offeree. Offerees reject, offerors revoke. The next one that we have is something called a counteroffer. And under the common law, it is required that the acceptance mirror the offer. Mirror image rule is what it's called, the mirror image rule. So it says if I accept, I can't change the nature of the offer. If I do, I've created a counter offer, which works as both a rejection of the original offer and creates a new offer. So the parties kind of switch places. So what would that look like? In my boat example, if I said, I offer to purchase a boat for $50,000 if you promise to sell it to me and deliver it Friday. And the seller who owns the boat says, let's say they say, I accept. However, you must pay $75,000 for the boat. Delivery Friday is perfect. I accept to delivery on Friday. However, you must pay me $75,000 for the boat. Even though they say accept, I accept. Delivery by Friday is doable, but you must pay me $75,000 for the boat. Initially, they say I accept to that. That doesn't even make sense, right? Why? Because the mirror image rule says, well, you can't accept and then change a fundamental term, 50,000 to 75,000. That's not a mirror image of the original offer. We might say, let's not use price because that's too obvious. Let's say he says 50,000 is fine, but delivery must be Wednesday, the following Wednesday. Well, would we consider that to be material? Yeah, probably, right? That's a material term of the contract, delivery, when an item is to be delivered. So again, that would then do what? If the offeree changes a term, doesn't mirror the original offer, we call it a counteroffer, which works as both a rejection of the original offer and the creation of a new offer. Why is it important to understand that they've rejected the old offer and created a new one? Well, because rejection of the old offer means that old offer can never be accepted. It's gone. The creation of a new offer, then, is the offer that's made by changing the terms. So the offeree now, who was the original offeror, can either accept or reject that offer or counter to that. So we could have counteroffer, 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 counteroffer if the parties continually change terms to the agreement. Oftentimes when we're analyzing these, we don't say, okay, the offeror made an offer and the offeree made a acceptance counteroffer, and then we don't switch the names of the parties. We still say offeror, offeree, which can be a little confusing, right? That's why they use this term counteroffer or counterofferor, because that makes it easier to retain the original offeror. And then we say the offeree made a counteroffer, counterofferor, the offeror said this, the counterofferor, right? And you're always talking about this weird, but really they flip, right? They flip if a counteroffer is made. Lastly, we have termination by operation of law. And so this is always a good discussion. I think lapse of time makes sense, especially when I've said that the offer remains open. So an offer remains open until it's terminated. So termination by operation of law says if we state a specified time frame, this offer will remain open for 3 business days, or this offer will remain open until February whatever, right? Until January 3rd. If it's January 1st, this offer remains open until January 3rd. We define a time period for which the offer would expire or terminate. Now, in the event that we don't put a time period in place, the law says that it will terminate by operation of law for a reasonable time frame, reasonable period of time. Better to write it in. Do we really want to try to figure out what reasonable period of time means? Well, that's litigated point. That's a court argument, perhaps, what reasonable period of time is. So we always want to put in a time that the offer will terminate, a time in the future that it will terminate whenever we write an offer. Destruction of the subject matter of the offer automatically terminates the offer. Death or incompetence of the offeror or the offeree terminates as well. It adds a caveat here that says unless the offer is irrevocable. Well, yes, because you can think about perhaps a situation where the offeror makes an offer to the offeree, and then the offeree accepts and then dies. Well, when would that be irrevocable? Well, the offeree has accepted. And what if it pertains to selling a vehicle or even real property or something, or a coin collection? Well, when the offeree dies, their estate would get that asset. Well, if the offeror and the offeree have agreed prior to the death of the offeree, the one who is going to sell the property, have agreed on a price, they're just waiting for a time period to close, and the offeree dies, then perhaps the offeror could go to the estate and say, listen, I have a valid contract between two parties. It's still enforceable because you have the asset. The offeree doesn't need to do anything. You can transfer it to me. I can give you the money. The money will go into the estate, and the estate can distribute the money to the heirs of the decedent, which I think makes sense. Supervening illegality of the proposed contract means that the subject matter, the legal theory or principle that is enacted makes the contract invalid because they've made the conduct perhaps illegal. We don't see that very much, but we could. Okay, we've talked about acceptance. This is, you can read over this yourself. I'm bordering on an hour now, and I apologize. Let me hit some highlights of acceptance here. As we said, an acceptance that adds terms is going to be a counteroffer and is not an acceptance. It has to be unequivocal, right? The mirror image rule says it must be unequivocal. You cannot change the language of the offer by your acceptance. If you do, you've created a counteroffer and you have rejected the original offer, which we talked about already. This is kind of interesting. There used to be some I remember when I was a kid, they would send out, I hate to age myself, but they would send out cassette tapes, and then by receiving them, they would say, if you keep these cassette tapes, and by your silence of not objecting to this, then you would become part of this program where we would send them more cassette tapes to you, and you would have to pay for them. Well, this is essentially by inaction or silence, and the courts don't allow people to do that. And you were never at any time on the hook to pay for anything that was sent to you by not sending it back, right? Because they would say, send the cassette tape back if you don't want them. Send it back with a thing saying, I don't want to belong to your cassette tape club or something, right? Well, the law said you can't do that. That's actually saying that you have been deemed accepted by silence or inaction, and the law does not allow that. We talked about communication of acceptance in a bilateral versus unilateral many times. The last concept here is the mailbox rule. This is an interesting concept for acceptance, but I want to give the punchline before we talk about the mailbox rule, is that you can completely render the mailbox rule inapplicable by contract language. So in your contract language, you would just say acceptance will be deemed effective at such a time. You just state it, right? You just state when the acceptance is to be effective. Because lacking that language in the contract, then the mailbox rule applies. And so what the mailbox rule says is that an acceptance is effective when it's sent. So if I'm sent an offer and I sign it and accept, I say I accept the offer and sign my name, and I fold it up, put it in an envelope, and I drop it in the mail. As soon as I've dropped that acceptance in the mail, it's communicated. Remember how we said that the acceptance takes effect when it's been communicated. So the mere fact of signing the contract and accepting it in my office doesn't communicate that acceptance, right? It's not effectively communicated until it has been sent to the other party. So you might say, well, that's weird, so they have to receive it. No, the mailbox rule says as long as I've dropped it into a third-party carrier's hands, the U.S. Postal Service, FedEx, whatever, it has effectively been sent. Once it's been sent, it's been communicated, even though it hasn't reached the offeror. That is essentially what the mailbox rule is saying, that acceptance becomes valid when it is dispatched. Dispatched meaning when it has been sent, dropped in the mail, sent to that third-party carrier for delivery. Not that it has actually been delivered, it's been dispatched, right? It's been dropped in the mailbox. So you can imagine that there could be some arguments about this, because what if it's not received until a week later? You sent it via snail mail, right? So the court has looked at that. Well, what's authorized means of communication? Well, the courts generally say whatever seems acceptable either in the previous history of the parties or what is acceptable in the business in which you guys are dealing, right? So if you've mailed stuff back and forth via snail mail before, that's probably acceptable. If the offer was sent via snail mail, U.S. Postal Service, and you sent it back via U.S. Postal Service, that again is probably acceptable. Again, if we don't want to worry about the mailbox rule, then in the contract language of offer, you should say this offer will only be deemed accepted when it has been received by the offeror. Or if the offeree signs the document or FedEx it and sends the offeror the FedEx tracking number on the date that the item is sent. You can put whatever you want in the contract. Remember, freedom of contract exists in a constitutional sense, by the way, and parties can agree on pretty much anything they want in contracts as long as it's legal. And so we'll talk about some of these other parameters of contracts in another lecture. I hope you enjoyed this one. This was way over my typical 30 to 40 minutes. I'm sorry. If you can't tell, I kind of enjoy contracts immensely, and we're going to continue to talk about contracts in other videos. So look for that. I will talk about consideration, a really short video on consideration. I'm going to try to keep it under 15 minutes, and then we'll go into the other aspects of contracts in an upcoming video as well. Thanks for your attendance, and as always, if you have questions and you want to talk more about the subject matter of the course or these videos, email me, or email is the best way to get a hold of me. Email me and we will set up a Zoom session, either private Zoom session, or I will attend one of the weekly class Zoom sessions, and we'll go over this together and make sure you understand it for the upcoming quizzes. So thanks for attending. I hope you enjoyed the lecture, and I will see you again.